Well, I'm really excited to be talking about this topic. I know that acts can't be very exciting, but this one has got some very serious implications, and it is very broad, and it's important for us to understand what this POPIA Act is all about. John Giles and Mark Heyink, they are both attorneys from Michalsons who help organizations comply with data protection laws like POPIA, which we're going to be talking about, in a practical and effective way. Gentlemen, firstly, thank you for joining me. Great to chat to you both. Let me start off with you, John. I mean, for those who aren't au fait with POPIA, this new act, what is POPIA and who needs to comply?
POPIA is essentially South Africa's data protection law, and it stands for the Protection of Personal Information Act. And it really applies to anybody who is processing personal data. And so whoever decides why and how to process, they need to comply, and they're called the responsible party. And the responsible party is very broad. It covers both private bodies, which would be companies and trusts, etc., and also public bodies, which would include municipalities, government departments. And so the scope is very broad.
Okay. When you talk about data, is it both digital and analog, kind of any forms of data, right?
Yes, so it's one kind of data being personal data, but then personal data in any form. So it can be in a physical record, it can be in a recording, it can be in a database.
Okay. Now, is anyone exempt from this particular act? Because I hear that there are some people exempt. Who should be worried and who's exempt?
Yes, so there are a few people who are exempt. One example is if the responsible party is outside of South Africa, then the Act doesn't apply to them, which is really a very strange situation because it means somebody could be outside of the country processing South Africans' personal data and not have to comply. But other than that, you exempt if you're using personal data for a purely household activity. And also, if you've de-identified the data, then it doesn't apply. And then there's some government departments like Cabinet and National Security that are also excluded from having to apply. And the last one, is that there's a journalistic exception as well.
Okay, all right. Now, it's quite interesting you mentioned about the external data, but I guess if I'm an organization in South Africa and I'm using Microsoft's data center, for example, and that data center might be outside the country, I'm still responsible for that data, right? It doesn't fall onto Microsoft because they're outside the country, the data center, right?
Yes, correctly. That it's the responsible party who's responsible, and they would still need to comply. Yeah.
Fantastic. So, I mean, Mark, we've been talking about POPIA for a very, very long time. And, some people say it's not going to happen, then it's back on track. But the president this year has said this is on track and it's going to happen. What are those timelines, Mark?
Aki, you're quite right. It has been quite some time, but the timelines are clear. The Act was proclaimed to have commenced, and there's a 1-year transition period. That transition period ends at the end of June. So from the 1st of July, anybody that processes personal information without complying with the conditions for lawful processing of personal information will be acting unlawfully. Of course, there are other compliance issues that we need to look at, but essentially, that's what you've got to do. You need to put yourself in a position that you can process personal information lawfully.
Okay, that makes perfect sense. And Mark, I mean, organizations already have tons of stuff to worry about. I mean, I don't have to discuss where the financial situation of our country is at the moment, and the businesses are under stress. Why should they care about data protection?
Okay, that's a very good question, and we often get this issue of compliance fatigue. But I think that one of the things that's very important to understand about data protection legislation is that it really is something that is happening globally. It is the way that it'll define how business actually processes personal information wherever you are in the world. And, we cannot ignore that. And certainly, from my perspective, I often say to clients that address me about this issue, it's just good business the sooner you embrace this, the sooner you do the right things, the better it's going to be, because if you don't, you may well disqualify yourself from doing business with partners that you would choose to do business with. They, simply won't do business with you if you don't comply in the future. So that's the one aspect. It's not really, for me, the compliance issues are important, but the business issue is very, very important. And I think that that's why businesses should actually be concerned and make sure that they deal with this legislation properly.
Okay. Now, I mean, just coming back to those timelines you were talking about, I was just thinking back about, we've had so many start-stops with this particular act. I mean, is it likely that POPIA will be delayed again? Is that a possibility? Are we definitely on track this time?
Well, firstly, we've got to recognize that we're pretty late in the game as opposed to many other jurisdictions around the world. And I think that the fact of the matter is that the POPIA in the form that it's in at the moment has been around pretty much from 2009, and it was actually enacted in 2013, and it hasn't been changed since then. So it's not as if people have not known that they've got to do these things.
Mark, we often compare our country to the rest of the world, and you've both said that the protection of data is something that's happening globally, has happened globally. It's really something that is not going to change. But how different is POPIA in South Africa compared to other global data protection laws, Mark?
It is very, very similar insofar as the principles that underlie how we've got to protect the data, the steps that we've got to take in the processing of the data. These principles have been around for quite a while, and I was part of the South African Law Reform Commission that researched and drafted the Act. And we were very careful. We looked to make sure that the law was pretty much harmonized with what is happening internationally, because it is an international development. So yes, there are differences from an administrative point of view. There might be differences around compliance. There are going to be differences around penalties, possibly. But the fact of the matter is that the principles that underlie how we process information are pretty much the same. There's a very, very strong overlap. And even though we have seen, for instance, the GDPR, which is really now the gold standard in the world of how we deal with information, and for those that don't know what GDPR is, it's the General Data Protection Regulation that governs the European Union. And that there are certain developments in the GDPR, like encryption. And that's quite a good example, because when we drafted this act, encryption was still very expensive. It wasn't being used extensively. Now we know, we encrypt our laptops. We've got these encryption mechanisms that are there, and those are important technological developments that the law will take into account as we go along. But certainly the basis of what we do is very, very sound, and it fits very neatly into data protection law around the world. It is properly harmonized with it.
Okay. All right. So, I mean, coming back to South Africa, John, what are some of the actions that organizations need to do and basically to start to plan ahead of this implementation? Where does one start?
Yes, so the place to start is with briefing your governing body. It's very important that your board or your exco is aware of what this issue is and what the impact is on your organization. Then you must get governance right, which includes identifying who's going to play the role of your information officer, which is the key person who is responsible for ensuring compliance with the Act. Then it's important to identify what software or platforms you can use to assist you with data protection. And there are many options, but they're fantastic tools that can help you do this better. And then you need to map your activities to create a record of your processing activities. You might do a gap analysis and then look at what action you're going to take.
Okay, I mean, you mentioned those processing activities. Does an organization really need to record those processing activities?
Yeah, it's interesting. It's difficult to apply principles to your activities unless you know what your activities are. What sort of personal data do you process as part of your activities? Where does that sit? What systems is it in? Which countries is it in? All of that's very important to know so that you can then apply the principles. And it's also required by law that you have that record and make it available under certain circumstances.
Okay, it makes perfect sense. Mark, is a gap analysis a place to start?
No, and there's this temptation almost to go straight into a gap analysis. We see it quite often. But it's one of those things, you, as John has just said, unless you know where you are, unless you've mapped your activities, how do you actually just start determining what the gap is? So I think that this is what we quite often see around how the organizations are addressing the POPIA activities. They tend to say, let's just get this done. And it's not a checkbox exercise. It really isn't. It is one of those exercises that you have to apply your mind. We all process our information differently for different purposes. And we'll use different technologies. And we really need to look at that carefully before we start getting into the gap analysis stage. And, you know, to do that, one of the things that I think is important, John mentioned software just now, but we need to get the right type of software to assist us. This is quite a big job in understanding exactly where we are, where we've got to be, what we've got to apply. So, you know, the Microsoft Compliance Manager is one of those tools that allows us to start looking at that and then using that to actually deal with the gap analysis, establishing where our priorities are, establishing where we've got to put our effort to reach the goal that we want to reach. So, you know, as I say, we see this quite often, but I think that quite often what happens is that we start doing a gap analysis without really understanding where we are, and that's a very important part of it.
So how much energy should organizations be putting into, you know, planning compared to implementing this this particular execution that we're talking about?
Well, in similar vein, and as John said, you know, first of all, we've got to recognize that this is not just a question of plug and play technologies that we can put into place to help us. This is a culture thing. So when you're changing culture in an organization, that's quite a big step. So as John quite correctly indicated, unless you've got your governance right, and unless you have your governing body actually championing this, you know, culture doesn't start at the bottom. It's something that starts with the example at the top. So I think that planning is important, getting people to understand. So what we do with how we approach it is we say, first of all, learn about this. What is it? And what have you got to do? Then spend quite a bit of time planning because it's a big thing. It's quite a big change. And I think that one of the things that is underestimated in the planning stage is how often we're doing lots of things purely because it's legacy. We've done it for years. We've processed information, but that's changing. And we're using different technologies. And I think that one of the benefits of this planning is that you're able to say, but why are we doing this? We can do it differently. We've got different technologies. So I think that there are a lot of unrecognized benefits of going through this planning stage properly. Once you've done that, the implementation becomes a lot easier. If you haven't planned, your implementation is going to be difficult. I would suggest that there are a lot of companies that are going to fail in how they look at the implementation. So I think it is very important to put quite a bit of effort into your planning. Your implementation will be so much easier. Things also like education. That's a long-term thing. It's not something that happens overnight.
Yeah.
And you need to think carefully about that. Otherwise, your investment is going to be lost.
Yeah, I mean, it's so interesting listening to the two of you. You know, companies actually have to have a massive mind shift in terms of how they look at this and look at the severity of this and just on how they treat data from every perspective. I mean, all the processes and implementation is one thing, but there has to be that mind shift that has to happen. And that's what I'm hearing from both of you coming through and through. Before you start, you know, planning and actioning all of these things, people need to understand the importance of this. And John, I mean, the reality is that there are always quick wins in whatever implementation you're doing. What are those quick wins when implementing these kinds of controls, for example?
Yes, sure. And maybe if I highlight 3 quick wins, the first is to focus on protecting account numbers. what Parliament in South Africa has done has said that if you fail to protect account numbers, it is a criminal offence, and potentially there's a fine of 10 million rand or 10 years in jail. And it's only account numbers, though. It's not other things. And this is one of the reasons we say to people that it's very unlikely that anyone will go to jail for contravening this act. But with account numbers, there's a greater chance, because criminals want account numbers so they can steal people's money or access their credit facilities. And so a quick win is to focus just on account numbers. The second quick win would be to implement an incident response policy. It's really a matter of time before you're going to have a breach. And it's very important to plan and to have a policy and procedures that make sure everybody knows what they're going to do when it happens. A little bit like a fire drill. A breach happens and you need to respond fast. You've got about 72 hours before you've got to report it to the regulator and then notify data subjects. It's important that we all know what we're doing, and it's a quick win because it creates a feedback mechanism whereby you can then analyze where you failed and then put things in place to stop it happening again. And then the last one is that you can create a complaints procedure to get data subjects complaining to you. You don't want them complaining to the regulator. You want them to complain to you so that you can try and resolve their complaints as quickly and easily as possible.
Okay, very interesting. I mean, I'm thinking out aloud. You talk about, protecting the account details. I'm thinking of two scenarios, for example, online e-commerce applications. I've got my account details stored on Amazon, which is outside the country, and I'm buying locally from a pet store, which is outside the country. My credit card details are on there, and I just click the button, instant buy, because it's already stored. If there's a breach on either side, there's different implications, right? Amazon's sitting offshore, the local pet company is sitting in South Africa. Those are the guys that, if there is that kind of breach, they're in big trouble because they've got those account details, right?
Yes, and it's very tricky when it gets to multiple jurisdictions because each country has slightly different laws relating to breach notification. And so responding to a breach that impacts many countries or data subjects in many countries is a very difficult thing to get right.
Okay. No, it's a fascinating law. Now, just coming and wrapping it up, gents, because it's been a fascinating discussion, and there's a lot to think about and a lot to process for many people watching this particular video right now. But I want to ask both of you, John and Mark, what are those practical actions that, I'm sitting down, I'm the CEO or the Chief Security Officer of my organization. What are those practical actions as an organization that we can start to take right now? I want to ask that to both of you. Who wants to go first, Mark or John?
Maybe I'll start with one really hot tip, and that is that passwords are often the weakest link, and we want to have strong, unique passwords throughout our organization. And the way to achieve that is to use a password manager. And so you can encourage everybody in your organization to start using a password manager, and that's a really practical action that you can take right away. And then I think a few other practical actions. One is to focus on your policies and have a look at and review them and see if you need to update them, and also see if you have any gaps and you need to add extra policies in different places. Another quick win, which I think can add a lot of value, is to decide to implement privacy by design throughout your organization. Essentially what this means is that going forward, if you're going to launch a new product or you're going to develop some new software, you need to be thinking about privacy and data protection as part of the design phase and build it in by default. And so this is about putting a fence at the top of a cliff, not an ambulance at the bottom, and really is a good thing for organizations to do. Maybe over to you, Mark, if you'd like to add a few.
Aki, I have three things that I think are takeaways. First of all, take it seriously. This is going to be important to your business, to any modern business. The second thing is expect a breach. As John has said, We are in a position where information is very valuable. And particularly in South Africa, we know that we are one of those targeted countries from a cybercrime perspective. Depending on your sources, we're either the second or third per capita in the world from the cybercrime perspective. So expect a breach. And just understand that the breach is what you fear most. Don't worry about the fines and that. It's the reputational damage that can come to your company. And if you expect a breach, first of all, if you're serious about data protection, you're probably going to avoid some of the breaches, but maybe not all of them. But when it happens, you've got to look slick. You've got to be able to say, this is what I've done. It's a little like we were caught, I think, globally with our pants down around the pandemic. And what did Bill Gates say to us? We planned for wars. We have war games, but pandemics, which he had warned us about some time ago, we didn't plan for. And I think that we've seen how we've suffered from that perspective. The other thing is that it's important to understand that this is a culture issue, and it will require training of people. We're dealing with people. That takes a bit longer to deal with than technological changes, and etc. Yes, we might have to draft policies that tell us how we got to use the technologies, but ultimately, the proof of the pudding is going to be how your people process personal information. So don't forget the culture thing. I think that sort of sums it up for me.
So, John, what lessons have you learned from helping different organizations?
Yes, one of the key things is that when a largish organization or one that has a significant impact, or data protection has a significant impact on them, it really makes sense to use software to help with this task. There is a lot of work to be done, and for example, creating a record of your processing activities, there's a lot of work to be done. And some organizations, we've seen them try to use spreadsheets, and you can very quickly get yourself into a mess. And so using software, like with many things these days, it just makes the task a lot easier, a lot simpler. It enables you to have dashboards. It enables you to get visibility and create proof of what you've done to comply with the law.
Okay, so you're saying that, follow digital process. There are incredibly good tools out there to help you with these kind of processes. And then, Mark, to you, where do people get the know-how for these kind of things?
Aki, that's a very good question. And in the South African context, there is quite a lot of material out there. And I hope that this doesn't sound too self-serving, and I take no credit for it myself. But John has developed an incredibly good website around data protection. It is, in my view, certainly the best website in South Africa to find information. The point about it is it's not just the information that is important from a data protection perspective in South Africa. What John has done is he's also scoured data protection authorities around the world and other sources.
Okay.
And you have links to some of the best, as we discussed earlier, we are not dissimilar to most of the jurisdictions. And the fact of the matter is that there's a lot of good practical guidance that we can get from other jurisdictions. And what John has done is he's gathered that information into the Michalsons program. And, for anybody that's starting and wants to understand how they've got to do this and gain the education and the awareness that they do, I really do recommend that they look at what John has put together in the Michalsons program.
Yeah, very cool. Listen, I'm going to throw a quick last curveball to both of you. I mean, what keeps you awake at night when it comes to this POPIA Act? Is there one thing that really keeps you awake at night? I don't know if there's anything like that, because as lawyers, you guys pretty cover everything. But John and Mark, is there anything that keeps you awake at night with regards to the POPIA Act?
I think
you start, John.
Yes. So for me, what's so interesting is that personal data is at the heart of so many things in society these days.
Yeah.
It determines who wins elections. It determines who gets credit, who gets to buy the house, who gets a job. It's really at the heart of so many decisions. And going forward, it's going to become even more important. It's almost like the golden thread that runs through all sorts of things. And so POPIA is really about saying, when is it lawful or unlawful to use personal data as part of those activities? And so it goes to the heart of many things. And unless we control it well and we abide by these principles which Parliament have set, we're going to end up with people being discriminated against, being excluded. We're going to increase the digital divide and really end up in a very bad situation as society.
Great words. And Mark, what about you? Is there anything that keeps you awake at night with this act?
Well, I think that John has really described this very well, because for me, I've been passionate about this for many years. As I say, more than 20 years ago, I started looking at the issue of the gap between law and our social and commercial reality. And that really fascinated me. And that drove me into looking at information security, because it gave us the disciplines about how we need to look at protecting the information. People would say to me, but there's no law. And I say, yes, there is a law. There's a law really relating to what you've got to do as a reasonable person. And even if we don't have legislation, doesn't mean to say there's no law. We've got to act reasonably. And what we do see is that people are not necessarily acting reasonably. We also have this psyche in South Africa that if somebody's got our information, well, also there's not much we can do about it. And what this law does is it tells us, yes, it is our information. We have a right, and we have a right to ensure that people do protect that information properly. So from the point of view of the data subjects, I share very much what John is saying. I think that there's a lot of harm that can be done. And, one of the examples that I use quite often is that the Industrial Revolution was not that long ago. And we had 5-year-old children put into coal mines because there were narrow seams and you dug narrow tunnels. It was just good economics to do that. And now we're in a situation where we are seeing our information very valuable. This is the same as the coal that fueled the first industrial revolution. This is the fuel of our fourth industrial revolution. And we need to make sure that this is not being abused. And because it has such a tremendous effect on people, as John has described, those are the type of things that I think are worth fighting for. They affect so many areas of what we're dealing with. And it really is a new dawn that we have to embrace and start understanding better to make sure that people are protected. It's not the fines that worry me that much. It's how do we protect people. Thanks, Aki. I think that tells you what I think
Giles,
about.
and John Giles, Mark Heyink from Michalsons. Thank you so much for chatting to me and discussing this very important act. Appreciate your time, gentlemen.
Thank you, Aki.
Thanks very much.